My Lords, good morning. May it please your Lordships, I'm Salim Moulan of the English and Mauritian Bars. I appear for the appellants together with Mr. Peter Webster of the English Bar and Ms. Angélique Devaux de Marigny of the Mauritian Bar. My learned friend Rishi Persam, Senior Counsel of the Mauritian Bar, appears for the respondent number 1, together with Mr. Nadim Lalmamod and Bilshan Nusimulu, also of the Mauritian Bar. The respondent number 2, the company whose shares are in dispute, is not represented on this appeal. My Lords, if I can just address you briefly on the procedural objection raised by the other side. What has happened this morning is that I received I saw it about 30 minutes ago, a response to the letter we filed on Friday. And what we would jointly propose, if your Lordships agree with that course of action, is that this they're preparing copies now, and the idea is that this would be filed with you when we break for lunch. We will consider it over lunch and respond as required just after lunch. So we may take a further few minutes after lunch. And the idea is that this would allow us to proceed straight into the merits of the appeal. The other side is happy for that course to run if the board is happy with that.
Right. I assume that is that's all. Thank you.
Very well, my Lord. So, with the board's permission, I will structure my submissions on the merits this morning as follows. I will start with some introductory words as to the appellant's case, explaining in particular how the two arguments in our case are put and how they interrelate. Secondly, I will then turn to address the relevant legal principles. I will start with that before the facts, my Lords, because it is, we respectfully submit, important that the board be given a proper explanation of how the relevant Mauritian civil law principles of interpretation operate. And because while there is now more common ground between the parties following service of the respondent's case on the law, there remain important areas of difference, particularly with respect to the relevance of extrinsic evidence of common intention. Thirdly, I will address...
You'll help us as to what the extrinsically evidenced common intention is said to have been, because I'm not very clear in my mind as to precisely how you formulate it or where you find it.
Indeed, my Lord, I can tell you now, it is evidence contained in the affidavit of Mr. Rivalan, Michel Rivalan, who was the former CEO of United Docs, and it's going to be at paragraph 6, 8, and 14, I believe, but I will take the board to it, expressing the simple idea that the clause was meant to apply to all shareholders, including UDL. Now, my Lords, we submit
that's obvious, because it's in an agreement with all and it refers to each, so that you don't...
But that it was actively meant to operate, because the case on the other side means that the clause could only be triggered with respect to 2 of the 4 parties to the agreement.
Well, unless things changed between sometime after the agreement, but before they suggested loss of control.
My Lords, that's where I think there are 2 ways to look at it. One, I think if you look at the contract itself without looking at extrinsic evidence from the CEO of UDL, and I should say confirmed and agreed to by all the other parties, so it is evidence of common intention coming from all 4. But even if you leave that aside, I would submit, just looking at the contract, that the clause, when drafted, was meant to operate from the time it was drafted.
And you say otherwise it would be ineffective in relation to UDL?
Indeed. And of course, the moment that is accepted, the answer to the case is clear. And we say,
On what basis, though? I mean, the answer is clear because you read the clause as doing what, or in what sense?
The moment you accept that when they drafted the clause,
it was intended
the parties intended it to apply from that moment onwards, then any answer that leads you to the conclusion that it could not have applied on any view to UDL and another party, DESMEM, must be wrong as a matter of interpretation.
This is put at too high a level of generality. You're still not telling me precisely how you say the clause should be read.
My Lord, the clause there. What happens?
In the light of what you say is this obvious understanding that it would have some relevance to, or likely to have some relevance at some stage to each of them.
Yes, and what I...
So how do you say that the intention is formulated, and how, as a result of that intention, do you say that the clause should be read?
My Lord, if one starts from that premise of mutuality, which you get to either through business common sense or by looking at the extrinsic evidence that that was the intention of the parties, what actually happened is that the parties in their clause used the word loss of a controlling interest. What do they then do? They define controlling interest by reference to an outside criterion,
Right.
which is the definition in the listing rules
Right.
of the stock exchange. Now, either by doing that, they were giving effect to their intention and assumption that there was a controlling interest applying that definition, or the language went wrong. And Mr. Revalant, as I will show you, explains where the language goes wrong. Because if you find a controlling interest for UDL, then yes, it is sufficient that you then have a loss of control, because the assumption is you have a controlling interest, it is lost. If the definition, which they incorporate by reference into their clause, doesn't work, that means that what you need to consider is a change of controlling interest. And that, of course, is not inconsistent, as my learned friend tried to put it, with the case of loss. All it said, because change encompasses both loss and acquisition.
I agree. I mean, on the face of it, it doesn't make any difference if you inserted the word change instead of loss.
You need to say acquisition or change.
Well, a change, my lord, I would humbly submit, includes an acquisition.
Well, if there hasn't been a controlling interest beforehand, then the controlling interest hasn't changed.
My lord, what I would mean is...
But what you're asking for, as I understand it, in answer to Lord Mance's question, is that you want the clause to read, should there be any change in any of the shareholding structure of any of the parties, resulting in the acquisition or change of a controlling interest of the shareholders, then the option arises. That seems to be what you're asking for.
Yes, I still submit that a change, again, would include an acquisition. And
the difficulty is that you're ignoring the next words. Which stroke who currently holds such controlling interest in said party? And again, you've got the use of the word controlling interest. So it's not just, you can't just substitute the word loss by acquisition. You've got the problem.
Yes, you have to airbrush out the other words.
How to airbrush out those words?
2 points on that, my lords. You wanted to see the evidence, and I will take you to it, so you see exactly what I'm referring to. But before we get to
your schema presentation, where
well, I'm afraid we're into the detail. We're interrupting you, but anyway, we get. Perhaps we should allow you to get on.
No, my lords, because if I may, and obviously so, as always happens here, you've hit the nail on the head. So we do need to address that question, and I would make 2 points in relation to the discussion we were just having.
Yes.
First. And I'm sorry to put it that way, but you have to be careful not to come at this wearing your rectification hats. You're engaging with a French law, Mauritian law interpretation exercise. And you will remember we gave you the passage from Chardbrook, which explains the fundamental difference of approach between the two. You're not here to try and say, well, is this too violent a change to the wording? That's not it. The basic principle in Article 1156 of the Civil Code is that whatever the words may have been, they must give way to the real intention of the parties. We've given you a case, I will take you to it, where it was written plot D2, it was meant plot D3, it's plot D3.
But it's still helpful to us, with our poor English approach to things, before we say to ourselves, we don't need to worry that this is a violent change to the language, to know what it is that you're trying to achieve.
Of course, my lord, and this is what I was...
what you're trying to achieve is it a change resulting in either a change of or acquisition of a controlling interest?
Yes, or one could put it differently.
And we take out the currently holds bit.
Or one could put it differently, which is a change in the prevailing situation of control control being defined by reference to the listing rules.
I would quite like, I was hoping we were going to get to your formulation rather than the formulations we're trying to put into your mouth. Well,
Yes.
How do you formulate it? What is your formulation of what you're trying to achieve?
Well, I think that the easiest way, because it is formulated in the evidence of common intention, is if I take you to the relevant paragraph. So if you would please turn to page 154 of the record, MS 154. So this is an affidavit of Mr. Michel Rivalan. I would draw the board's attention to the fact that there are two Rivalans, and unhelpfully both with the first name Michel. One is Michel Guy, and this one is Michel. Michel Guy is for Rivnu. Michel Rivalan was the CEO of UDL at the time the shareholders' agreement and the option in clause 11 were concluded. And you see that at paragraph, so he's responding to an averment by Mr. Galea, who's taken over UDL, and he addresses the intentions of the parties, clause 11 of the agreement, in paragraphs 4 onwards. And I would draw your attention to paragraph 6. The option set out in clause 11 is a mutual undertaking given by all the parties, which could be exercised upon the happening of an event, such event being a change in the controlling interest within any one of the parties. The said option to purchase and force sale is one which cuts both ways. That is to say, it could be an option in favor of UDL in the event there was a change in the controlling interest within any of Desmond, Rivnu, or PIM, or it could be the reverse, forcing UDL to sell its shares in the company in the event of a change in controlling interest within UDL. At paragraph 8, he goes on to say this. In view of the fact that the company was an investment holding company, it was important for UDL, Desmond, Rivnu, and PIM that the persons at the helm of each of the companies all shared similar investment policies, vision, and way of doing business in relation to the company. The parties agreed to protect this preferred relationship by inserting clause 11, which forced a sale of the shares in the event this relationship was disturbed by any raider or for some other reason resulting in the change of control within any of the parties. This change of control would result in a change of the persons at the helm of any one of UDL, Desmond, Rivnu, and PIM, a situation in which the parties did not wish to be placed in relation to the company. Clause 11 precisely catered for such a situation and is the situation in which UDL finds itself by the change in the controlling interest on the board.
This affidavit is quite carefully phrased when it uses the word within rather than in. Because change of control within one of the parties is not a very apt way of referring to a change of control in the shareholding of one of the parties. And the last sentence indicates that what he's talking about is a change in the controlling interest on the board. That's the way the case was put below.
If I may,
that's not quite what the clause is talking about, is it? If it had said a change of the controlling interest on the board, you would be home and dry by virtue of what happened in October.
My Lord, what is, again, you need to think about the purpose which was being pursued and which Mr. Rivalan, in my humble submission, makes clear here, which is that if you have a change of shareholding which brings about a change in the prevailing situation of control within the company, within one of the shareholders of Axis, then the clause was triggered. And I'm going to show you, my Lord, because it is said now that we have changed our case from the way it was put below. It's now triggered by the change of shareholding rather than by the directors. I will show you that below both points were wrong. We said, what needs to happen is that you have a change of shareholding resulting, as drafted, in a loss of controlling interest. Now, that result can be coincident. That result can happen at a later stage. When you're talking not of, the listing rules, of course, have two limbs. One is automatic, objective. You pass the 20% threshold for control. The other is effective control. Even if you don't have 20%, you have the capacity to appoint or remove the directors. Now, the moment you talk about effective control, then of course it will become more granular exactly when that effective control has changed hands. Is it at the moment when the shareholding itself was acquired? And I will show you that there is evidence to say that. Or is it when that effective control materializes on the board by actually taking the control? So the case was run both ways. But again, my lords,
Well, you'll show us that. You'll show us.
I will. But perhaps I should go back to the course of my speech.
Yes.
Thank you. So I was saying I'm going to address the relevant legal principles because we do submit that it is very important to understand the role that extrinsic evidence of common intention plays in French and Mauritian law. And I should have said, my lords, and I will make that good when we come to the facts, that what Mr. Rivalon says in his affidavit is adopted in terms by all three other contracting parties. So what you have before you is express common evidence of intention from all four parties. And my lords, I would ask that if you only take one thing away from that extrinsic evidence, it is this, that the clause was meant to be mutual from the moment it was drafted. If one reaches a conclusion whereby the clause could not have operated at the time the SHA was concluded, you are not giving effect to the intentions of the parties. And I will show you there are two ways in which one does not get to that result. So after having gone through the law, I'll address the facts on each of the appellant's two arguments, and I will conclude by briefly addressing some of the points raised by the respondent in their case. And in that last respect, with the greatest respect, my lords, the appellants respectfully submit that the board should exercise particular care when relying on the respondent's case, which we humbly submit, unfortunately misunderstands, not to say misrepresents, much of the appellant's case, and I wouldn't make that submission without making it good, and I will at the end of my oral submissions this morning. My lords, the present appeal, of course, concerns the proper interpretation and application of an option to purchase shares, which was negotiated in or around May 2006 between the main shareholders in the second respondent, which I'll refer to as the company, namely Rivnu, PIM, Desmem, and the first respondent, UDL. The company itself is a party to the shareholders' agreement. Rivnu, PIM, and UDL each held 20% of the shares. Desmem held 29%. The document that was meant to record their agreement as shareholders, the SHA, is dated the 30th of June 2006, and the option was set out in Clause 11. Now, Clause 11, my lords, you've already been looking at, but if you take it perhaps from page 13 of our case, and that's at page 584 of the brief. And the reason I ask you to look at it there is that you have in the next paragraph the two limbs of the definition of controlling shareholder in the listing rules of the Stock Exchange of Mauritius. And as you have seen, the option to purchase was expressed as being triggered where there had been any change in the shareholding structure of any of the parties, I emphasize the words any of the parties, resulting in the loss of the controlling interest of the shareholders or shareholder, who currently holds or hold such controlling interest in the said party. Now, Clause 11.2 defines controlling interest by reference to the listing rules of the SEM, and the listing rules define in turn a controlling interest in two ways, either of which will suffice to establish control. First, you've got a purely objective test, as I was saying, which consists in holding 20% or more of the shares of the company. Secondly, you have an effective control test, pursuant to which a shareholder who does not own 20% or more of the shares is still deemed to control the company, where he is de facto, my words, de facto, in a position to control the appointment and or removal of directors holding a majority of voting rights at board meetings. And my lords, it is common ground that a change in shareholding structure took place in July 2006 when a company called Horus Limited acquired 18.27% of the shares in the respondent number 1. There is also no doubt that this resulted in the acquisition of a controlling interest by Horace, as defined in clause 11. Indeed, as I will show the board later this morning when addressing the facts, the point appears to have been conceded below that an acquisition had taken place. And in any event, it is clear on the facts. Now, the dispute between the parties arises because the new management of UDL says that applying the literal meaning of the words used by the parties in clause 11, the word loss of, combined with the words controlling interest as defined by way of the definition incorporated from the listing rules, there was no existing extent controlling interest as defined in UDL at the time the shareholders' agreement was concluded or at the time Horace acquired its shareholding, so that they say no controlling interest was lost when Horace acquired control, and so that clause 11 was not triggered. Now, our case is that this is a technical argument based on the literal wording of the clause, and that it flies in the face both, we say, of commercial common sense and of the obvious purpose of the clause, which was meant to and expressed to apply equally to all the parties to the SHA. Now, irrespective of whether one gets it to, should it be a change, should it be an acquisition, if you start from the premise that there was, in fact, no controlling interest in UDL, then that clause could never have applied to UDL at the time the shareholders' agreement was concluded. And we say, we humbly submit, that makes a nonsense of the clause and of the clear intention of mutuality which is in that clause and in that contract, irrespective, I submit, of whether you look at the extrinsic evidence or not. So that's just on pure interpretation of the words. So it flies in the face of that. It also flies in the face, their interpretation of the clause, of unanimous evidence, which I have now shown you, from all the negotiating and signatory parties to the SHA, that this was indeed their intention, i.e. that the clause should apply equally to all the parties to the SHA, including UDL. Now, as a matter of interpretation...
You have to, and the difficulty about this is, of course, there may have been an assumption, but they may not have actually covered the situation which existed. So you say we have to change the wording of the clause so as to make it apply. You can't be saying, are you, that there is stopped or precluded from showing that there was no shareholder who currently, or shareholders who currently held a controlling interest?
That could have been an argument. It was not run below. I'm not running it. Of course, one could say...
They can prove the facts. So you then have to show that although the facts don't fall within the clause, nonetheless, we must expand the wording of the clause to cover the facts. Well, that's the argument.
With respect, and it's utterly normal, but you're still coming at this from an English law point of view when you say we must change the words.
By the fact that Mauritian judges have also come at it from this point of view, so I think there's a limit to the force of that point.
No, what I mean to say is simply this, my lord, that what you need to look at when you say, well, if the words that they use, and I emphasize that, look at the way they drafted the clause. They used the word loss, and I would humbly submit, on the assumption that there was a controlling interest.
Do you rely on the word the? I mean, if one reads the loss of the controlling interest of the shareholder which currently holds it, which one might thought implies that an assumption that there was a controlling shareholder. It doesn't say any.
I do.
You do rely on that.
I do, and what I say is this. These parties clearly thought they were drafting a clause that was applying to all four of them.
But you said that about
No, I'm sorry, I'm being sorry. But yes, the way they do it is that they assume there is a controlling interest. They therefore use the word loss. But when they define controlling interest, clearly they think, how should we do it? Oh, there's an easy definition, which is in the listing rule of the stock exchange, which, as we will see, also tallies with the definition of the Companies Act. So they use that.
But who, I mean, if the word the implies that there was a controlling interest of a shareholder in UDL at the time, what is the evidence of who that controlling shareholder was?
Exactly, my lord.
You'll be coming on to that later.
We're going to come to that.
Because
So
that's one paragraph in the two affidavits that we're landing on, where the two companies agreed to sell the shares at a premium, and you infer from that they were acting in concert.
Indeed, my lord. So I was going to say the two ways in which you reach, we humbly submit, the right result is either first applying the words use, i.e. the word loss of, and the listing rules definition of controlling interest. There was, and that is a question of fact, as a matter of fact, an existing controlling interest at the time the shareholders' agreement was concluded, which was then lost. Now, this first argument, as I said, raises a pure question of fact. It does not turn on any reliance on extrinsic evidence of intention or any correction to the words used by the parties. And we've referred to this in our letter of Friday as the...
Your first case means that even if the clause means what the respondents say, you come within its terms.
I'm grateful.
The second argument is if you don't, if those facts cannot be found on the evidence, nonetheless, you have your Mauritian law interpretation based on a proper understanding of French law.
Indeed, my lord, and that is quite simple. The second argument is that if the application of the listing rules definition of controlling interest, which I emphasize again are incorporated by reference by the parties into clause 11. Why do I emphasize that? Because we all know this can cause clauses to go wrong. And so they incorporated into reference, but if that test does not yield the controlling interest, which was extant at the time the SHA was concluded, as I humbly submit the parties clearly thought it should, then the words used by the parties in clause 11, what we would call in French and Mauritian law their volonté exprimée, does not reflect, these words do not reflect or tally with the parties' real intention, their volonté réelle. And my lords, that is the test, which is why, my Lord Mentz, I didn't mean to, of course, one has to try and see how the words are made to work, etc., etc. But that is, if I may say, the approach of, and I'm part of it, of course, I practice here, but of the objective interpretation of a contract. In France, what matters is what was the volonté réelle. And I humbly submit, the volonté réelle was on any view that this clause was going to apply to UDL at the time the shareholders' agreement was concluded. Now, any interpretation which leads you to the opposite result does not correspond to their volonté réelle.
Could you just explain why it has to apply to UDL at the time of the shareholders' agreement? Why can't they be providing for a regime to cope with the situation which might arise in the future if first A and B acquire and exercise a controlling interest, and then it changes to C and D?
Yeah, well, I think first on the wording of clause 11 itself.
That's where currently comes in, is it?
Exactly, currently and the word the.
Yes, I see.
Also, if you look at the scheme of the shareholders' agreement, you've got a number of provisions, and I will show those to you later this morning, if we ever get to it. Clause 10 of the agreement has a series of restraints on the transfer of shares, quite stringent. And what they show, even without going to the extrinsic evidence, is that this was a close-knit company where the existing shareholders intended to retain their existing relationship. Now, with all due respect, Lords, it makes, we humbly submit, no sense to say, well, they were drafting a clause catering for the future. They were drafting a clause, clause 11, which was meant to be consistent with clause 10. It was a clause that was meant to apply from the moment they concluded the shareholders' agreement. And that, with respect, is the difficulty with my learned friend's case. It proves too much, because the only way in which they can get this option not to apply is by going all the way to saying there was no controlling interest. Well, if there was no controlling interest, then that clause could never apply to UDL at the time the shareholders' agreement was signed.
So what was the Clause 10 procedure operated in relation to Horace's purchase of the shares?
No, Horace purchased shares in UDL. No, my lord. The restraints on the of Clause 10.
I'm sorry. Yes, it's on the company's shares, not UDL's. Of course.
But that is why it's relevant, because if you read Clause 11 the way the other side are asking you to read it, then Clause 11 allows one to completely circumvent the restrictions in Clause 10, because rather than purchase directly shares in the company, all you need.
Where do we find Clause 10 set out?
Clause 10, my lord, is at...
Starts at page 70 of the record.
And we referred to it in our case. Now, this second argument, which an English lawyer would probably see as rectification, but which, as a matter of Mauritian law, is a second step in the process of interpretation, raises an issue of law as to when one may go beyond the words of the contract to ascertain the party's true intentions, and an undisputed issue of fact as to what those intentions were.
Well, is there any evidence that parties actually addressed their minds to a situation where there was no current controlling interest at the date of the shareholders' agreement?
The evidence, my lord, is that the parties must have assumed that there was one when
yes,
they...
But that's the problem. So they didn't address their mind to what you accept is a position which it's open to the respondents to allege and to prove. Now, I agree on your first argument. You say that that isn't the position, but if you're wrong about your first argument and there was no controlling interest at the date of the shareholder agreement, then it's quite difficult for you to say that the parties addressed their mind to the actual position and intended to cover it.
Well, the parties addressed their mind to the wish to retain the existing relationship within the company. In doing so, they drafted a clause which was intended to apply to all four contracting parties. And my second argument is to say that if, by using the word loss, together with importing the concept of controlling interest from the listing rules, that yields a result which does not comport with what they intended to achieve, that must yield to what they intended to achieve.
What they intended to achieve is, the point I was putting to you, difficult to discern, because actually they were under a misapprehension, is your primary case. Namely, they drafted this clause on the basis that there would be a controlling interest, and if there isn't, they've simply failed to focus on or intend anything in relation to the actual position.
If there isn't, my lord, what they meant is that the people who were at the helm of UDL, who were acting for UDL within the company, would remain the same. And that is covered, as we were discussing earlier, my lords, by the concept of acquisition being added to the concept of loss.
So what you say the people within the company would be the same. In other words, the directors. So we have to read it not as focusing on controlling interest in UDL. We have to read it as if the directors of UDL change.
My lord, with respect, no, because
board changes.
No, because controlling interest is defined by reference to being able to control the board. Either you're assumed to be in that position if you have more than 20% of the shares, or there is effective control where you are in fact in that position.
Right.
So the test to that extent does reflect what they were trying to achieve. Where it may have gone wrong if one is not able to identify a controlling interest within UDL at the time of signature of the shareholders' agreement, is to assume, and I will show you why, because for 20 years the same team had been at the helm of UDL, that a controlling interest as defined under the listing rules applied to UDL. Now, again, if that fundamental assumption which underlied their agreement, which was their intention, was wrong, then the clause must be made to align to the purpose they actually wanted to achieve. That is the second limb of the argument, my Lord. I should simply here, before moving on to the law, briefly make the point that as I think my Lord Mance has already indicated he sees, the two limbs of the argument are in no way contradictory as asserted by the respondent. They simply represent the two ordinary steps one goes through under French law when searching for the party's true intentions. One starts with the words used and tries to make sense of them. That's the first step. That's the first argument. If this tallies with the party's real intentions, including in a situation where there is no reason to doubt that it does, or no evidence to the contrary, that is an end to the inquiry. But where it does not, the real intention must prevail. If I may take a few minutes, my Lord, to make that good on the authorities, if you could please look at tab 18 of the authorities bundle. Pages 818, 819. And this is, I'm sorry, if you just turn briefly back to the first page, you will see it's the jurisclasseur fascicule 10, contrats et obligations, interprétation des contrats, l'instrument, notion, norme et champ d'application. And at paragraph 40, Professor Simler of Strasbourg University, who drafts this part of the jurisclasseur, is talking about the méthode, volonté déclarée. And I'm sorry, my lords, I'm going to be reading it in French. Le principe est une chose, la méthode, so he's talking about how one goes about the exercise of interpretation, en est une autre. Étant admis qu'il faut par priorité respecter l'intention des parties, comment les intentions peuvent-elles être perçues par le juge? Si l'on raisonne par l'hypothèse la plus commune, où il existe un écrit, il faut assurément scruter d'abord le contenu de l'acte, i.e., you start with the text of the agreement. Then, at paragraph 41,
Why don't we read the next words? Aussi imparfait que soit le langage comme véhicule de la pensée, si la formulation est claire et dénuée d'ambiguïté, elle doit être tenue pour exacte pour des raisons évidentes de sécurité de commerce juridique. So if it's absolutely clear and unambiguous, you stick to it.
I will come to that, my lord, because that is the question of denaturation.
Yes.
And absolutely, my lord, we will come back to that. At the moment, I'm just showing you the methodology of the two steps. So you start with the agreement. Then at 41, about 7 lines down, the author says, Professor Simler says, en définitive, l'article, 5 lines down, en définitive, l'article 1156 n'oppose pas dans ces deux propositions une volonté interne à une volonté déclarée. Il envisage seulement l'hypothèse de la discordance entre la volonté effectivement déclarée, pour peu qu'elle puisse être prouvée, et son imparfaite expression écrite. I.e., the second stage is you check whether the words used correspond to the actual intention of the parties, where that intention can be proved. And he says in the last line of that paragraph, last sentence, l'esprit, en d'autres termes, doit l'emporter sur la lettre. And over the page, at the top of the page...
The example given of a will expressed in francs made after new francs had come in, but nonetheless intended to refer to ancien, old francs, is probably rather an obvious one if you look at the amounts in the question.
My lord.
There'd be hugely, one would be millions and the other would be thousands.
Yes, but it was a question that exercised the French courts for quite some time when there was the transition.
One point I just want to ask is, this refers to Article 1156. This is in the French Civil Code, is it?
And also in the Mauritian Civil Code. It is
we've got the same base, have we?
It is the same. It's very unfortunate that now with their reform of the French Code, they've changed all the numbering. So it's going to make the task for people in Mauritius very difficult indeed, and I mean that. It's going to be, very difficult. Anyway,
But the text of the codes is the same, isn't it?
The new code, no, they have
Not. I mean, I know there are some procedural differences in France.
Oh, sorry. This text is exactly the same. What you're considering here, I thought you meant the new code. No, it's exactly the same. It's exactly the same.
When did the new one come in?
Last year? I will tell you, Lord.
So we must be careful in the future.
In the future, you will have to. In the future, we will all have to. Over the page, my Lord, top paragraph. Au total, la signification de l'article 1156. And just to remind you, it is the article which provides that you do not stop at the literal meaning of the words. You must search for the actual intentions of the parties.
Have we got the text of the...
Yes, you do, Lord. You can look at it at tab 1.
Thank you. Just as long as I know where it is, that's all right.
Page 641 of the record.
Yeah.
Perhaps I'll... Yeah. That is the cardinal principle of interpretation under French law. You do not stop at the words used, you look for the real intentions of the parties. And this is what Professor Simler says. Au total, la signification de l'article 1156 est assez simple. Dès lors qu'il est établi par quelque moyen que ce soit, I emphasize those words, by any means of proof, qu'il y a discordance entre la volonté réelle par hypothèse exprimée fût-ce tacitement et la formulation écrite ou même orale de cette volonté, la première doit l'emporter. Il n'y a là aucune, Lord Mance, I draw your attention to that, il n'y a là aucune contradiction avec la théorie de la dénaturation. Une clause peut n'être claire et précise qu'en apparence. Tel est précisément le cas si la discordance ci-dessus décrite est établie. Rien ne justifierait que l'apparence l'emportât dans cette hypothèse sur la réalité. So, and at this point in time, Lord, I was just showing you that you have a two-step process. First, you try to make sense of the words. Secondly, you look at the wider context, you search for their real intentions, and you may, in those circumstances, look at anything, including extrinsic evidence, to try and establish the real intention. Continuing on that point, if I could show you how this board approached it in text services, which you find at tab 15 of the bundle. And the passage, the relevant passage is paragraph 20, which you find at page 780 of the transcript. And you see here that Lord Mance is referring to one of the passages we have just read, probably in an earlier. So at paragraph 20 on the top of page 780, the quote is from Simler's writings in the Juris Classeur. And then the board looks first at the words used and then says, but these paragraphs have to be read in the context of the letter as a whole, and the letter itself has to be read in the light of any relevant background and all the factual circumstances. Then from paragraphs 22 to 27, you have a textual interpretation, which concludes at 27, and you see the last sentence which says the message sent by the words, this message should be further tested by reference to background and other factual circumstances. And at paragraph 44 on page 792, the conclusion is there. In these circumstances, there is nothing in the factors on which the judge drew from outside the language of the contract which gives any significant support to a view that the contract has any meaning other than that which flows from its language as a matter of ordinary construction. Any residual weight which any of them bears is insufficient to outweigh that meaning. In particular, the general commercial consideration which the judge thought could be identified either dissipate entirely or pale into insignificance when the nature and commercial background of the contract are properly recognized. So even in a case where there was no extrinsic evidence, what you do is you start with the words of the contract and then you consider it in the wider context. And the final reference below is at paragraph 61 of the fascicule 20. So you have two writings from Professor Simler. One is fascicule 10, the other is fascicule 20, which you find at tab 19. If you could turn please to pages 873, 874. Paragraph 61. And he's dealing here with dénaturation.
What does dénaturation mean?
Dénaturation, well, I will take you to an authority which explains what it is. But in a nutshell, what happened is that when the Civil Code was promulgated for quite some time, the Cour de Cassation would not review interpretation at all. And you understand that when you realize that the Cour de Cassation is not like this board, a court with full powers. All it can do is break for méconnaissance de la loi, for an error of law. So for many years, it just took the view that interpretation was a question of fact, therefore we're not going to review it at all, whatever happens, happens. Then in 1872, there was an arrêt de principe. And what did that do? It said that in certain circumstances, where the judge has gone too far, they would act. And I will show you the exact limits of that power. And he explains it here already. He says, la dénaturation est la méconnaissance flagrante du sens d'un acte qui était clair et précis et qui ne requérait par conséquent aucune interprétation. La Cour de cassation ne censure pas l'erreur d'interprétation, fût-elle certaine, mais seulement l'abus d'interprétation. So you're looking for abuse, not error.
Sorry, abuse, not error. Yes.
Abuse of interpretation. So la clarté et la précision, he says, peuvent au surplus être analysées suivant différents critères, linguistiques, grammaticales, logiques. Il n'est contesté par personne qu'il faille, en outre, tenir compte du contexte économique et social dans lequel l'acte s'inscrit. Il faut rappeler enfin que l'intention commune des parties doit l'emporter sur le sens littéral des termes, ce qui autorise les juges du fond, pourvu que leur décision soit motivée et que soit détruite, I emphasize those words, et que soit détruite la présomption de concordance entre la lettre du texte et la volonté réelle des parties à s'écarter sous couvert d'interprétation de stipulations ayant toutes les apparences de la clarté et de la cohérence. And that is translated, my lord, I should have said, that particular passage at page 609 of the brief we've put in a translation.
Wait, where is it translated? 609?
609. But I continue in the French, I'm sorry, and that is not translated, I believe. Dans les dernières hypothèses citées, il apparaît que le contrôle de la dénaturation s'apparente fort à un contrôle de la motivation. So what you're checking for is reasoning. Have they properly reasoned why they're departing from the words of the contract?
You're talking about the motivation.
Motivation.
De la Cour.
De la Cour. Exactly. So that is what dénaturation...
I'm sort of having, my French is not great, and I just want to make sure I can catch up. You say this is translated somewhere.
It is translated as 609, yes.
Annexed to your case, as I understand it.
Okay, well,
So could you give us the internal page number
Yes,
of your...
page 3.
Right.
Yes.
The annex.
You're looking at...
The top, in blue.
It's not coloured.
That bit, unfortunately, is not covered.
Go to our 61, yeah.
But, so what Simler says, and I will translate it, that particular sentence, dès lors que les juges du fond justifient par une motivation plausible le fait qu'ils s'écartent de la signification apparemment claire de l'acte, la censure pour dénaturation ne peut être prononcée. So, as long as the judge of first instance has justified with plausible reasons, with plausible reasoning, why he has departed from the apparently clear meaning of the document you're construing, la censure, you can't break the judgment for dénaturation. So, my lords, all
that's
this
not our problem. We're not trying to correct the reasoning of the judge, or at least you're the one who's trying.
No, my lord, but this is important for two reasons. I've taken you to that for two reasons. Because below, the reason the courts were made not to look beyond the words of the clause at all, including not looking at other clauses in the contract, is because of that 1872 arrêt. That is what was produced, and it was said you would be doing a dénaturation. And I'm going to show you there's no question of dénaturation whatsoever in the present case. But the reason I was taking you to this now is to show you that there are two steps under French law. Both are treated as interpretation. It's not, as we would do here, interpretation and then rectification. Both are interpretation, but they do remain separate stages. So when my learned friends come and say, oh, you're running inconsistent cases, with all due respect, we are not. We are doing exactly what Simler says one ought to do, which is you first try to make sense of the words. If you cannot, or if you reach a conclusion which is clearly incompatible with the real, la volonté réelle des parties, you give predominance to that volonté réelle.
Are there limits on that operation of the second stage where the interests of third parties may be prejudiced? I have in mind this, that the shares in UDL presumably were tradable, and presumably Horus sought to acquire a controlling interest and pay a premium for them in the belief that they wouldn't be dispossessed of them under an agreement such as this. We don't know from the evidence whether Horus saw this agreement beforehand, but one would imagine that given their aim, they would want to know about it. I mean, are there provisions in the French code to protect third parties?
My Lord, I haven't looked at the specific question.
It's rather important because
third parties, yes. We will look at that. But if I may say factually, my Lord, they were on notice of this, because you have a communiqué by the management of UDL, which you find at page 97 of the record. 97. And that's when the whole battle is raging. And they say, vu le climat de tension qui a prévalu au sein du conseil, I'll let you get them, 97, so it's a communiqué from UDL. Vu le climat de tension qui avait prévalu au sein du conseil d'administration, the board, de cette compagnie au cours des dernières années, la protection de l'investissement pour chaque partie était assurée par une clause au contrat donnant droit à chacune des parties de racheter l'autre au cas où un changement drastique intervenait dans la direction de l'autre partie. Nous voudrions donc informer nos actionnaires qu'il est possible que cette option soit exercée si la composition du conseil d'administration changeait drastiquement à l'Assemblée générale.
This is United Docs.
A communiqué
at some stage, what date?
4th of September 2006. So when the battle...
That's before the opposite negotiations for the UDL shares.
no, there's after the purchase of the shares.
It's after the purchase of the shares.
But my point is, what notice did they have of this interpretation before they purchased the shares?
Well, factually, I will come back to that point, my Lord, but I would draw your attention to this, is that you're not, what the option is doing is not dispossessing anyone of value. You will remember that 11.3 of the option provides for fair valuation of the shareholding at the time of disposal. So what the option is doing is simply ensuring the close-knit nature of the company, but as you would expect, because they could all be on the receiving end of this. You're not talking about prejudicing the party that is going out, other than not being able to...
I don't know, if you bought a company, you presumably spent quite a lot of money on professional fees and things, and a lot of time and effort.
Well, you've also paid a premium rate because you think you're going to get control.
No,
Would, under 11.3, would the other parties to the shareholders' agreement have to pay the premium rate?
Well, that's my concern.
Yes.
but the premium is paid within UDL. You're not paying a premium rate.
My Lord's point is the real point, isn't it? Why the other parties already have control among themselves. They're just going to add a little bit to their shareholding, presumably pro rata, is it? Would they pay a premium rate for that? They're not acquiring anything. They're not acquiring control, which they didn't have before. They could always act in concert before. They have to act in concert afterwards.
Well, I think we're talking about two companies. There's control of UDL and there's control of the company.
Yes.
Yes, and they had a controlling interest in the company, but they didn't have a controlling interest in UDL. The parties to the shareholding agreement.
Well, I understand the question to be, was Horus on notice? UDL, you will remember, is a massive company. I mean, this is a part of UDL. So there are many, many assumptions.
There are lots of
assumptions in the question. You're talking of...
Not just a vehicle to own this company.
No, it's not a holding company of this. It's a massive... It owns half of the port in Port Louis. Yes. It's one of the historic traded companies in Mauritius. So with respect, I don't think that point really arises on the fact, and it's certainly not a point that has been taken by the other side. But in any event, if one were to have to look at, and you have to remember, so the drop-down value of the shares of this particular small company owned by UDL, well, UDL is not hard done by because it is receiving, as of the date where the option is triggered, fair value for that. It hasn't paid a control premium for shares in Axis. Horus has paid a control premium to control UDL. And actually, this is by the by, but the reason probably they did that is that there was another battle for control of another company called Arel Malak, and they were trying to get control of Arel Malak. This is really a complete sideshow of the acquisition of UDL. Now, my lord, if I may turn... Oh, I think we're going to have a minute's silence in a moment, but if I may turn to the law.
My lords, ladies and gentlemen, Her Majesty's government has asked that the nation observe a 1-minute silence at midday today to remember those affected by the attack in Finsbury Park last week. As the time is now approaching 12 noon, we ask all those in the building at this time to stop what they are doing and stand in a moment of remembrance and reflection. I will announce when the minute is over. It is now midday. One minute has passed. Thank you for your mark of respect.
Yes, I can see what you mean, that this may be a sideshow, given that the size of UDL and this particular investment being of limited significance. But the point has to be tested. The point of law has to be tested in other circumstances. And I would be very anxious to know what are the restrictions on the use of the second stage of the French interpretative process to protect third parties, yes, just as we have protections of third parties in our law of rectification.
Yes, my lord, I see that. And if I could say, and it's a point which I would be making also when we get to the facts of the second point, it is not my submission that because the parties have all come together after the event and put in affidavit evidence which is clear to say, well, it was meant to be triggered in those circumstances, that the court, the board, then just has to act on that, as if they could trump everything that has happened, including perhaps trumping third-party rights that would be infringed. You, the board, will of course test that evidence for plausibility, which is why I have said, and I repeat, that what we draw from the extrinsic evidence is really this very basic notion, this one word, mutuality. The parties meant for this clause to properly apply, to all four shareholders. That's all I'm driving from the extrinsic evidence. If somehow you feel driven by the textual interpretation to get to a situation which is the only situation they can contend for, where it would not apply to two of the parties. That is all I get from the extrinsic evidence, and I say that is entirely plausible. That makes business common sense, it tallies with Clause 10, it tallies with the framework of the agreement as a whole. But I will come back to that, my lord. Perhaps I don't have much time left, and I would like to get on to the law. What I've done to try and save some time is put down on paper 6 propositions of law that we make, and I will then take you through those as we go.
Thank you.
Well, first we say that, as noted by Lord Hoffman in Chartbrook, the French philosophy of contractual interpretation is altogether different from that of English law, whereas English law depersonalizes the contracting parties and asks not what their intentions actually were, but what a reasonable outside observer would take them to be. French law is concerned to identify and give effect to the actual party's actual intention. Further and importantly...
Can we read it to ourselves?
Sure, my lord.
Does the fourth point not operate the other way around, in fact? I mean, you're saying that denaturation is a limited doctrine, so we can... but actually, it's a limited doctrine in a court which has a limited jurisdiction, like the Court de Cassation. Maybe a court like the Court of Appeal in Mauritius or the Board, the scope for intervention is greater rather than less.
Yes, my lord, I think
that's your point, yes.
That is my submission, that denaturation has no role to play here. You, as you have done in the tech services case, my lord, you just interpret, and that's what I'm here to try and help you do. And so this...
Yes, but denaturation is a restriction on review. We might have a greater power of review. I'm not sure. Does it mean there's a greater power of to give effect to parties' intentions?
My lord, I wouldn't want to spend time on whether denaturation applies or not. At the end of the day, the test, the legal test as to how you interpret, that is a matter of French substantive law, which doesn't turn on denaturation.
That's what we're concerned with, isn't it? Yeah.
Well, yeah. If I can take all of these points in turn briefly. On the first point, my lord, I will simply refer you, if I may, to paragraph 9 of our case. You do not need to turn it up. It's page 577 of the record, and this gives relevant references to Chartbrook, to an article from Professor Valker, which is referred to in Chartbrook, and to an article by Professor Vogenauer, or perhaps Vogenauer. Second point is conceded by the respondents, as I have indicated. The third point if you look, please, at the respondent's case, which you at page 634 of the record is paragraph 55 2A. And the respondent concedes there that the court should not restrict itself to a literal interpretation of the contract, but rather ascertain the common intention of the parties, bearing in mind the context in which the contract was drawn up, as well as the surrounding circumstances. But if you look back at paragraph 54, they try to exclude from consideration every other clause in the contract. And that is on the basis of a clause in the shareholders' agreement. If I could ask you to turn that up, you will find it at page 59 of the record.
It's 126.
Indeed, my Lord.
Paragraph, it's page 60 of the record.
It is. And clause 1.2, as you see, is a collection of general boilerplate clauses. And as we have submitted in our case, clause 126 is just that. It's a common boilerplate clause. And we respectfully submit that the obvious purpose of which is clearly to allow severance of any void or unenforceable provision. It is drafted in a manner designed to maximize the chances of the offending provision not infecting the rest of the contract. But it is not meant to, nor does it, we respectfully submit, displace the normal rule of interpretation that clause 11 is to be understood within its contractual setting. Now, the respondent's submission amounts to a submission that one may have regard to all of the context and surrounding circumstances, save for one of the most relevant, which is the contract itself. And we humbly submit that does not make any sense.
In point 5, little 5, they say that even if that's wrong, it doesn't matter.
No, because they have misunderstood with respect to the argument. We're not saying that clause 10, however they put it. They say, one fails to understand how clause 10 is an aid to interpreting controlling interest in clause 11. My Lord, what we have submitted, as I was submitting earlier this morning, is that clause 10 contains a series of restraint on the transfer of shares. You must read clause 11 consistently with that, which means reading it as applying to everyone in the same way as clause 10 does, but also reading it in a way which doesn't allow a party to readily circumvent all the prohibitions on direct transfer simply by ceding control higher up the chain. And that you find that in many commercial contracts. Now, you may agree with the argument or not agree with the argument. We think it's a good argument. But the idea that you're somehow debarred from even looking at clause 10, we humbly submit, is quite far-fetched. Now, this is all the more so when one bears in mind that the Mauritian Code Civil, like the French Code Civil, expressly sets out the normal rule of interpretation that clauses must be interpreted by reference to the other clauses. That's Article 1161 of the Code, which you find in that same tab 1 of the authorities bundle. And we don't dispute, the other side have come back saying, oh, but that's not mandatory. Of course, we don't dispute that 1161 is not mandatory. It isn't mandatory, and we have never contended otherwise. But we do say that particularly clear words would be required to displace such a basic and important canon of interpretation, and that clause 126 doesn't do that. These parties clearly did not intend to mandate a court not to have regard to any other clause in a contract when construing the rest of the contract. Now, I pause to note, my lords, that this is an error which was made by the Court of Appeal, and that this must throw considerable doubt on the Court of Appeal's interpretation of Clause 11.
Sorry, the error being just...
Being to rely on 126 to say, that's it, we look at the clause and we look at nothing else.
Well, it meant they didn't have regard to clause 10. Yes.
Well, it meant, yes, it meant they didn't have regard to clause 10, but I think, and I'm not going to take you to the Court of Appeal judgment now, my lord, but it's clear that the Court of Appeal was taking a very restrictive approach to its task of interpretation, which we humbly submit was the wrong approach.
Paragraph in the Court of Appeal? That's paragraph.
My lord?
Court of Appeal, where's the reference?
Could you...
523 onwards.
yeah, and that passage as well. It's at page 527, my lord. I apologize for the delay in giving you that.
527.
527 of the
Line
document.
19. Yes.
Right. Yeah. Thank you.
Well, turning to the fourth point, if I may, that is considered by the respondent, as I have indicated. We've had a brief exchange with Lord Mance about the first point, which is really of academic interest, but it may well arise at some point. I think it's just that when one comes to argue these appeals, you realize that people don't always think about the interaction that arises from the fact that we are a Code Civil country, but with English procedure. And sometimes that does have an impact, and this may well be one of those. Be that as it may, it is important we submit to understand the limited scope of the doctrine of denaturation. If we could do it in English, perhaps, that would help some of your lordships, and that's that Vogenau's article, which you find at tab 21 of the authorities, pages 925, 926.
Nine.
925. And perhaps if I may leave your lordships to read the passage which starts at the Cour de Cassation. Oh, I'll read it. The Cour de Cassation.
Yes, no, we can see that.
The
Where do you
Cour de
want to
Cassation
read?
continued to uphold the doctrine
Down to where?
down to the
Far-fetched
end.
interpretations at the top of the next pages.
Exactly.
Ah, yes, thank you. Right.
Thank you, my lord. And yeah.
Well, that's broadly consistent with the similar text, isn't it?
Indeed, my lord. If I may, and I will simply note that the reference you see at footnote 38, because of course these are just names and sometimes it can be lost. But Professor Terret, who's quoted here, is really one of the foremost civilists of the moment. I mean, he's quite elderly now, but that is the reference given here. And then I'm mindful of time, if I may give you another reference, which is to Simler in the Jurisclasseur at pages 873, 874 of tab 19 for the same point. Well, actually,
But the fact,
it
I
is
mean,
the passage.
I do find it a bit confusing referring to an appellate doctrine. The fact that judges in France or in Mauritius in France, I think, let's confine ourselves to France, have a wide freedom to engage in fairly far-fetched interpretations doesn't mean that we, as effectively a court of first instance, are free to do what we like or engage in fairly far-fetched interpretations. In other words, we're not subject to a limit which is purely by reference to the doctrine of denaturation. We're required to arrive at the right interpretation.
My lord, that is my respectful submission. You do not look at the question through the narrow prism of denaturation. You do what your lordship
Well,
did.
denaturation is a narrow curb on far-fetched interpretations, but it doesn't mean to say that all the interpretations which pass the Cour de Cassation would be right if we were reaching them as effectively a first instance.
I accept that, my lord, I accept that, but you
So we have to make our own mind what's appropriate, applying the principles of primary principles of interpretation, which you referred us to.
Indeed, my lord, but you will bear in mind, and I'm sorry, I'm repeating myself, that the submission made below and that was retained was that because of denaturation, the court could not look beyond the clause.
Well, that does seem, I take your point.
Now, the fifth point, my lord, is conceded, and I've given you the reference. The sixth point is important in our respectful submission. And we say it's absolutely clear on the authorities that even where a clause is clear and unambiguous, clair et précise, it must give way to the parties' real intentions, which can be established by any available means of proof, where it doesn't reflect those, and that, again, that doesn't give rise to any issue of denaturation. If I could ask, again, because of time, my lords, if you could look in your own time, but it is a very relevant authority from the Mauritian courts themselves, Harpal and Prayag, tab 11, page 752. And it's a case where, that's the case I was referring to earlier, where the deed referred to plot D2, but Mr. Justice Garrick took into account evidence of intention and background circumstances to depart from the absolutely clear words of the contract.
It was a misdescription of the parcel, was it?
Yes.
Lord, yes. And Mr. Justice Garrick said that at page 754, in our law of contract, the predominant consideration is the true intention of the parties. In the event of a conflict between their true intention and their intention as expressed, the former must prevail. Then another case, my lords...
A bit like the French francs in a different sort of way. I mean, they were talking about one specific piece of land when they inspected it and so on, and but they put the wrong description in the contract. Is that...
As we will see, my lord, these are helpful in that when it's French francs or when it's a specific plot identified as D2, you will remember that what the authors are struggling with in France is this idea that you cannot interpret the clause that is clear and precise because you may fall into denaturation. So the examples they are giving you is not to say it only applies then, it's a fortiori. Even there, where it could not be clearer, it could not be more precise, you still give effect to the common intention of the parties. And I will show you how, with respect, I think Professor Simler explains that perfectly. I'll just give you one other reference before we go to his writings, which is Rabot, case called Rabot of 1998, Mauritian case. Authorities, tab 12, page 758, where the judge said at 764, dans cette œuvre d'interprétation, le juge peut écarter les termes utilisés par les parties s'il est démontré que, and he quotes, malgré leur clarté, les termes invoqués pris dans leur sens littéral étaient incompatibles avec l'ensemble du contrat et l'intention évidente des parties. And there's a reference here to a French judgment of 1926. Perhaps, my lord, if you just open page 764.
It's tab 13.
Yes. Yeah. I would invite you simply to note in the margin that the arrêt from the Chambre des Requêtes, I'm sorry, it's on page 764, yes. Requête 15th of April. You can find that, if you want to look at it, at tab 7, page 701. And it does exactly what is said here. Now, if we could now go to the Juris Classeur, fascicule 20, which is tab 19 of the authorities, it's page 856.
All right.
And you see, he's addressing here, if you look at the title, number 2, deuxième, clause claire et précise, contraire aux intentions réelles. So he's addressing, we submit, the exact situation that arises under our second argument. And at paragraph 23, which I believe you will find at least a partial translation of it, MS 611. So in that annex, yes, if you go to page 5 of the translation annex, You've got the French, and on page 6, you've got the English.
The translation annex is where?
It's attached to our case. I think it should be
Actual
just
case,
after.
yes, I see. Yes, it's the
Both on
annex.
page 5.
Very helpful.
Yeah.
Yeah.
And I'll just take it from the English, my lords, at page 6. It is possible that the stated intention of the parties is apparently devoid of any ambiguity, but that it nevertheless does not correspond to their real intention, if only because the parties have made a mistake as to the meaning of a term or expression. The very use of the terms stated intention and real intention dictate the solution. French contract, founded on consensualism, gives precedence to the parties' true and profound intention over the terms used to declare that intention. If this abstract principle must be strongly tempered on the simple basis that the judge can only give effect to an intention if that intention has found some external expression through some mean, it nonetheless follows therefrom that it would be out of the question to impose on the judges of fact a strict obligation to stick to the literal terms on the sole ground that those terms are intrinsically clear and precise.
There's got to be some kind of external expression of it. You can't have two people who subjectively intend the same thing but don't communicate it to the world at all.
Well, the testimonial proof of the contracting parties under French law is admissible evidence. Again, my submission is not that it trumps everything, but my submission is that where it is plausible, where it is coherent with the other indices of proof, it certainly is exactly the sort of expression of real intention that a French court would look to in doing that exercise.
But Professor Simler here is talking about an error of expression. You intended to say something and you didn't say it. What seems to have happened here is there's a factual error on which the contract was drafted, namely that all the contracting parties did have a controlling interest at the date of the contract. Now, is that covered by Professor Simler's commentary?
Yes, my lord, and we will go to what he writes in the fascicule 10, because when he told the error that is described is when the words that have been used do not give effect to the real intention of the parties. Now, it may be an error of the type my lord has just described. It may be more simply that the intention they had, this clause was to apply to all of them, is there was going to be a change in the prevailing situation of control, is drafted in a certain way. And why? Because they assume there is a controlling interest, therefore they say, of course, if we lose it, so they use that word loss. And you put that together with the way they define their controlling interest, which was to import an outside definition. And with respect, one can see if the language has gone wrong, which I will turn to in a moment when we look at the facts, but you can see how the language may have gone wrong. And what Simler is explaining is that when you conclude that, yes, it has gone wrong.
But I mean, if you're not answering with respect to my Lord's question, assume that the mistake is not as to the use of the words, but as to the underlying factual situation. Assume that's the position. Is that covered in this text?
Yes, my lord. I will show you when he explains the legal analysis in fascicule 10. I'm sorry, no, it is the extract here at paragraph 29 on mistake, where he's dealing with erreur bilatérale. If you turn to page 858.
Well, this is translated page 6. Isn't it?
Some of it is, yes. And you see that the example he gives, so he explains that it would be an approach which would not give effect to the real intentions of the parties would directly contravene Article 1156. And the example he gives on page 858 is of a case where a été ainsi censuré l'arrêt qui avait étendu de 80 à 1400 mètres carrés la superficie de terrain. I'm sorry, it's the example in paragraph 29.
Where are you reading?
Second paragraph, is it?
Yeah.
Or mais une erreur supposée.
Is that it?
What does the paragraph begin?
It's the second paragraph, mais une erreur supposée.
Thank you.
Yeah.
And the next paragraph. No, the error, I humbly submit, is not restricted.
I'm sorry, I haven't quite understood what the factual situation is being described here.
This is a case where
Who interpreted the contract as extending to an additional 80 square metres simply because a car park was necessary.
320, it's an additional 320, I think. You're quadrupling the size of the land that's been let.
Oh yes, quite.
On the basis that the tenant can't do without it.
Right.
And that was acceptable.
no, that was censured, but it gives you so that was found to be in violation.
That's a denaturation.
That's too much.
That was a
That was too
denaturation.
much.
But I'm drawing your attention to the example because you will remember that the denaturation here is because there's no reasoning whatsoever. But what the judge is engaging with properly is to look for the true intention of the parties. And I humbly submit the next paragraph
It would
makes
be
that.
nice to see an example of them allowing something on the basis of a factual error, which is analogous to this case, but you don't seem to have one of them.
My Lord, a factual error analogous to this case. In the misdescription case on the plot of land, it's also a factual error in misdescribing. And what I'm...
No, it's an error of expression. They both agreed what it was they intended to sell, but they described the plot of land, which they both intended was part of the deal, incorrectly in the document.
But my Lord,
so that's pure error of expression.
But my Lord, with respect, the submission I'm making is that by incorporating by reference the definitions in the listing rules, that is the error of expression. You've got parties who assume they have a controlling interest.
I'm sorry, the assumption of a controlling interest in all the parties is a mistake of fact, which seems to have informed the wording of this contract.
My Lord,
not an error of expression.
It is a mistake of fact. Why, my Lord? Because controlling interest is then defined by reference to the listing rules. If controlling interest had been expressed differently by saying the presence of Mr. X and Y on the board or some other criterion, there would have been no problem. I'm sorry, my Lord, maybe I haven't
But
explained
that
the point.
assumes that there was a controlling interest which you're able to define and which they failed to describe, but I'm still not clear what you're saying the controlling interest was, the relevant controlling interest in UDO.
I will come to that, but on this point, as to whether it's an error of fact or misexpression by the parties, what I'm trying to bring to the board's attention is this, that in expressing, in trying to enshrine their agreement, the parties referred to external rules as to control. And I humbly submit that that's where the language may well have gone wrong, in the same way as describing, it's more complex, of course, but in the same way as describing plot D2, referring to plot D2 when you meant to refer to plot D3, you refer to a definition of control which doesn't achieve the purpose you meant to
Yes, but
achieve.
that begs a question, which apparently you're going to come to, as to what you say the parties thought the controlling interest was.
Well, let's come to that.
Before you get to that, you're having an understandable difficulty in trying to get through to English heads a completely different approach to construction. That I understand, and you've set it out. We'll do our best. But the judges from whom you're appealing were very familiar with this technique of construction, were they not?
Well, save that, they approach the whole exercise that you have seen through the prism. They could not look at other clauses of the contract.
They seem to have felt that what you were asking fell the wrong side of what's permissible, even under the relaxed method of interpretation which is adopted under the French Code Civil.
But this, my lord, is because they held that the clause was clair et précise,
Yes,
which is why,
You say that was an error.
that was an error, and this is why this sixth principle is so important. My lord, it is not a principle that was brought out before the courts below. No, it's not a new point. It's a legal argument I'm making to this board.
They made a mistake of looking for ambiguity, whereas there is no need to do so.
Precisely, my lord. Precisely. Because when there is a mistake, when you've got two stages to the process. First, you look at the words used and you try to make sense of them. If that tallies with the real intention of the parties, fine. If it doesn't, you must give effect to the intentions of the parties. And that's, I'm now going to show you on the facts how this works. Starting, my lords, with the first argument, where did control lie? Now, as we were just discussing, I do submit that looking at the clause in its commercial and contractual setting, the parties must be taken to have intended that Clause 11 would apply to each of them, and therefore the assumption which underlies Clause 11 is that the test of control incorporated by reference would yield a controlling interest. So that's how one approaches the exercise of looking for the controlling interest. Now, that's hardly surprising, this assumption in the case of UDL, when one considers that the same management had been in place within that company for some 20 years and had been representing UDL within the company ever since its creation in 1996. So you've got a continuity of management over 20 years. So the idea that therefore these parties assume, well, we are controlling this company is entirely consistent. As we have explained in our case, the courts below failed to approach matters on the
Sorry, where you just made that statement, where's the evidence of that?
I don't recall any findings of fact about the period of control of UDL.
My lord, I will give you the reference in a moment.
If it's in the affidavit, it isn't contradicted, is it?
Yeah.
Yeah.
It's in the affidavit.
I mean, if we're going to make assertions of the facts which underlie this, we do
Of course,
need
my
to
lord.
know where those facts are to be found.
And I'm sure my learned friend will address it if he disagrees, but I'll give you the reference in a moment. I'm sorry, my learned junior sent it to me this morning and I forgot to note it on my notes.
But we have to be careful, this isn't a fact-finding court. We are looking at the facts as found by the courts below.
Let's find out what the evidence is.
But I suppose there wasn't any oral evidence, it's all on the affidavit.
It's all on the affidavit, my lord, which is why we say you're in as good a position to...
Well, unless there was a challenge to something in one of the affidavits, in which case it wasn't resolved. But if it's there and not disputed, maybe.
My lord, we'll come to that. So, if I can ask you first to look at the judgment of Mr. Justice Lam Shang Lin, page 454. And if you look at page 465, you will see how the learned judge at first instance approached the issue. And his burden of proof, and he's addressing the question, the burden is on the applicants to show who was that shareholder in the singular. And then he referred, if I may let the board read this penultimate and final paragraphs on page 465. Well, so it's clear he's looking for a single controlling shareholder. And I pause to note that the paragraph he relies on here have been through the transcript of submissions below, which the board will find at pages 416 to 445 of the record quite carefully. That wasn't a submission made to him. So he went through the affidavit evidence and latched onto this particular paragraph and then makes it the basis of his judgment. The Court of Appeal upheld the judge's reasoning without adding any reasoning of its own, and you find that at page 528.
So was that challenged, that particular finding?
In the ground of appeal? It was, my lord. What was it? Ground 2. You find ground 2 at page 524. The learned judge erred in finding there existed no controlling interest in UDL at the time of signature of the shareholders' agreement or at the time Horace purchased the shares. The learned judge failed to take into consideration the evidence of Mr. Révalant, which is precisely that we rely on. And I'm going to show that to you in a moment. Now, if we look, as you can see, the Court of Appeal relies on the same passage from the affidavit. Now, if you look at that affidavit, please, which you will find at page 287, is the responsive affidavit from the appellants.
Sorry, what page?
287. And this is an affidavit from representatives of the other three shareholders, all three of them together, Noutet, Lagesse, and Mervin. 4.7, which the judge relies on, you will find at page 289. And then if you go back, please, to these gentlemen's first affidavit at page 20.
Page 20.
20. So that's their first affidavit.
Same people.
Same people. Yeah. And at page 20, you find paragraph 59, where the same point was already made, that UDL argued that since no shareholder, singular, had the control of UDL prior to the purchase of the shares, there could not be any change in control. If you just look higher up that page, in the same affidavit, if I could ask you please to read subparagraph 11. So paragraph 5711 of the affidavit filed by the appellants, the very first affidavit in the trial, in the main case.
Which contains the assertion of Anglo-Mauritius and La Prudence between them, usually.
My lords, yes, and I will show you that this had already been stated in terms by Mr. Michel Rivalant in an affidavit already filed on the 15th of May at paragraph 13, page 137 of the record. And Mr. Rivalant was the CEO of UDL at the relevant time and would have had first-hand knowledge of these matters.
Yes, I mean, so the words are identical. Yeah.
The words are identical.
Which page are you on now?
137.
Monsieur Rivalant's affidavit.
So that's effectively the high point of the evidence of control as it was before
The wrong
the
reference.
acquisition.
Wrong reference. Where is it?
What are you
I'm
asking?
sorry, it's at page 158. Please forgive me. 157. 157.
Yeah.
My lord, yes, I accept it. That is the evidence we rely on. But I will show you it is consistent with the way in which Horus then acquires control.
Yeah, but your submission has to be that the parties at the time of the shareholder agreement assumed that there was something called control, and that's what they meant by it. Is that right?
The CEO of UDL, when responding to Mr. Galea's very first denial that there was a controlling interest within UDL, answers that. My Lord, that is exactly the definition of effective control under the listing rules. The power to appoint or remove directors. And what then happens, my lords, is that those same companies...
But wait a minute. Let's just look at the, a bit more closely at the definition.
You'll find it at page 13 of our case.
Somebody has always elected the board, but because there's a vote of the shareholders, it doesn't mean to say that there is any shareholder or block of shareholders which has a controlling interest.
Well, what you're looking for is effective control. Effective control is defined under the second limb as being in a position to control, as being de facto.
There's got to be one. That's a definition which talks of one shareholder. And now everybody accepts that you can have a group of shareholders who together have a controlling interest, and Clause 11 contemplates that.
Yes. And my Lord,
shareholders who currently hold such controlling interest. But are you saying that if you had 100 shareholders who each had one share in a 100-share company, they would be the controlling shareholders?
Lord, I'm not submitting that.
You're selecting. What criteria are you using to select these three as the controlling shareholders?
Looking
the fact that they usually represented a large majority, or what?
And as he says,
and had
in fact appointed the then board of directors of UDL. That is the relevant criteria. Sorry?
Supposing you've got 100 shares, 5 shareholders, 20 each, A, B, C, D, and E. For the last 5 years, on the whole, in fact, nearly always, on anything of any importance, A, B, and C have voted in one direction, and D and E have tended to go the other way. Okay? And for some reason or other, it doesn't matter what, change of mind, came into money, new wife, whatever, C changes his mind and starts voting with D and E instead of with A and B. Is that a change of controlling interest?
But there hasn't been a change of shareholding structure.
No, there hasn't. And that's
so you don't even start getting into the question of controlling interest.
Just as effective, isn't it?
What is the effect? What is the effect in the listing rules of there being a controlling shareholder? What does it do? What does the controlling shareholder have to do?
Have we got the rules? We haven't. No.
Because
I don't believe we have them in the bundle, my lord.
But maybe we ought to see that.
Yes, we will obtain them over lunch.
There must be a big calculus.
Yeah.
Because I mean, the fact that two entities, let's say that 5 justices are all own 20% of a company, the fact that 2 don't attend, 2 tend to support the board and one tends not to. Does that mean that the 2 who are 40% of the company would have well, I suppose 40% is not a very good figure, but you take my point. Does that mean without concert between the 2, those 2 who represented 40% of the vote at the annual general meeting, but not 40% of the total shareholding? Again, that's a bad example. I'm sorry. Start again. If you assume that 2 individuals tend to vote in a certain way, but they don't have any agreement or there's no understanding and no concert, is that sufficient to give rise to a controlling interest in terms of the listing rules?
My lord, but that, with respect, that is not where the evidence ends. The evidence is clear that these parties together, and you're talking of three parties that are controlling about 20% of the shareholding. You're not talking of everybody acting together. You're talking of a company, it's in the record, and I will give you the reference, with about 1,700 shareholders. These three that only control about 1,900. Right, thank you, my lord.
1900.
So these three had, says Mr. Rivalan, who's the CEO, in fact appointed the then board of directors of UDL. And he says that Horace knew that by acquiring Anglo and PAD's shares, it was getting a controlling interest. It paid a premium for it. And if I can show you what Horace, because it does, my lord, if it does feed into that question of what is effective control.
I was just looking at the documents which seem to suggest that it wasn't absolutely a done deal. This was quite a big speculation. They thought they might well, and they pulled it off. But there was a hefty battle in September before the vote to appeal to the other shareholders, who presumably most of them still didn't turn up.
Lord, two points on that, if I can go in order, otherwise I'm conscious of the time. I will answer that exact question of what Horace thought it had achieved in July and August. I will take you to a document that shows that quite clearly. But first, and that goes to that question of what is effective control. Remember, what is Horace doing? We say there are three companies, Anglo, PAD, and La Prudence, that are together, have effective control, have been appointing the board. They are the ones who have placed this board there, which we say is the definition of effective control. Horace acquires the shares of PAD and of Anglo, and see what it says in its very next set of accounts, which you will find at page 2, I'm sorry.
But we know it's entered as a subsidiary, if that's what you're...
Yes, my lord. Yes. But could we see how it's said?
Everybody accepts that Horace, that the new shares led to a situation where Horace effectively controlled the composition of the board and was a controlling shareholder. So do you need to go further?
It's just what I would like to show you is
The problem isn't what happened after the change of shareholding. The problem is what was the position before.
Yeah.
And that's what I was trying to get at.
Yes, my lord, but what was the position before is what Mr. Rivalan is describing in his affidavit. So you've got three companies that have appointed the board, and he says they've appointed together. So this idea that they may have been acting completely independently, I humbly submit, is contrary to the evidence of Mr. Rivalan. He says they appointed this board. Two of these companies then get their shares sold to Horace, and if I may humbly ask you to look at page 323.
The problem with focusing on this passage, which appears in two affidavits in identical terms, is that it's been now deployed in relation to a case which doesn't seem to have been really run below. It's not suggested that, I'm not suggesting that excludes it, but I'm suggesting it makes it quite difficult to accept that it goes as far as you propose.
My lord, that is the evidence, but it doesn't stand alone. May I please ask you to look at page 323, which is the accounts and the way it is couched. 323. And the point I'm trying to make, my lord, is that the threshold for control under the definition adopted by the parties incorporated in their clause is low. It's 20%. And there's a reason for that. It's the reality of listed companies, where you will have a number of disparate shareholders and where it's possible to hold control with a low threshold. So automatically, if you're at 20%, you are a controlling shareholder. Even below, if you have the capacity of appointing or removing directors, you're one as well. And what Horace clearly says is, we only hold 18.27% in UDL, but we control the board, having nominated more than half of the directors to the board. And we say, it's not just the evidence of Mr. Rivalan standing alone. It's the fact that Horace acquires these shares, pays a control premium for these very shares, and then in its very next set of accounts says exactly, answers the question, if I may say. It says, we don't really own the 20%, but we have got that effective. It's not saying, but we are going to need the support of all the other shareholders for the next 20 years in order to retain control.
I think you're addressing a point which is a given.
But don't save that.
This was a considerable, got sufficient other shareholders either to abstain or to support it, for it to be able to get its nominations to the board through, and it accepts that it therefore, through those directors, controls the board.
Yes, my lord, but I humbly submit it feeds into the earlier analysis as well, because the whole argument was run below by saying we needed all these other shareholders in order to control the company. But the fact and truth is that ever since they have controlled the company, they purchased the controlling block, they did a coup in October to actually get the seats, but I will show you what Mr. Galea already did in July and August, which is only consistent with his clear understanding that by acquiring the PAD and Anglo shares, he had purchased control.
Yes, I don't have any difficulty with that as a principle. What is bothering me is whether the evidence on page 20 in 5711 goes far enough to say that before both those companies' shares were acquired by Horus, they were acting in a way that they would be treated as a controlling interest.
I respectfully submit, my lord, that you're looking at the definition of a controlling interest to try and give effect to the intentions of the parties. And this is where the whole discussion we had before, with respect, feeds in. That you are approaching this exercise, not trying to see, was there one? Could there have been one? Yes, the parties meant this clause to apply to all of them. So you're going into the exercise, trying to find where it is.
Well, hang on, I understood your first case, which is what you're on at the moment, was that even if the other side's right in their interpretation, then factually you are within that interpretation. Secondly, if that's not correct, then you pray and aid your various submissions on the French approach to contractual interpretation. So if we keep those two arguments separate, as I think you have pleaded them separately, then I ask again, how am I to infer from 5711 that Anglo-Mauritius and PDL acted in a way which meant that together they had a controlling interest?
Well, as to how the two cases interrelate, I'm sorry if I wasn't clear. The fact that the mutuality element is as much part of my first argument as it is of my second argument. I say you don't derive it from the extrinsic evidence. You derive it from the purpose of this commercial contract, from clause 10, we say it's obvious that it should be mutual. And therefore, I repeat, you approach the exercise looking for where control lied. And I submit, of course, taking that evidence alone, we may not go far enough. If you look at how matters actually developed, how Horus itself recognizes that the acquisition of this block of shares acquired by paying a control premium actually did give it control. And if I may just show you two final documents on this. Page 104.
Right.
This is a communique from UDL of the 15th of September. And you see that Mr. Rivalan, who signs this letter, says in 1 and 2 that on the 13th of July, Jean Piat, chairman of UDL, met Cyril Maire and Dominique Galea of Horus. At the meeting, Mr. Piat was asked to assist them in getting the majority control of the board of directors on the basis that Horus was in the process of acquiring 18.27% of the equity of UDL. As a matter of principle and in line with good governance practices, the request to obtain control of the board by a minority shareholder was not accepted. On 11th of August, next paragraph, Messieurs Maire and Galea met the chairman in the presence of the chief executive. The offer of 2 board seats was again declined by Messieurs Maire and Galea, who requested 7 board seats out of 12. My lord, that is only consistent with Mr. Galea and Mr. Mayer having realized perfectly well that by purchasing these shares, which I repeat, were 2 of the 3, and which they're still controlling with La Prudence. So you've still got the same 3 companies. It's no longer La Prudence plus PAD plus Anglo. It's now La Prudence plus Horus. And they don't say, well, hopefully we can get the control, the support of all these disparate shareholders who've only invested in this company as an investment. Hopefully we can get that. They don't say that. They immediately come to the board prior to the purchase and immediately after the purchase.
Mr. Gallia controls La Prudence, and he also controls Horus.
Exactly. So they knew where control lay.
So you're saying, in effect, are you, that all this is clear, plus the Horus accounts, is clear evidence that Horus had, through some kind of titanic struggle, wrested control or acquired control of UDL. And so are you saying it follows from that someone must have had it from whom they have wrested it?
I say that allied with the evidence of Mr. Rivalan as to who had appointed the prior board, when you see it's the same companies. And my lord, when you say a titanic struggle, you will remember that titanic struggle only happened because this board didn't cave in. What they clearly were doing is, having purchased the controlling block, they came to the board to reap their reward. And because the board would not do what could well have been said, yeah, okay, you've purchased the block, it's yours.
Shareholders at large, and
yes.
pointed out that the income had fallen from, or surname perhaps, the income had fallen, profit had fallen from 22 million in 2001 to 10 million in 2005. So not surprisingly, the shareholders were attractive.
My lord.
And one would be interested, of course, it's entirely irrelevant to the issue to know what happened subsequently, but that's a different matter. And you needn't tell us.
The test is one of effective control, my lord, and that is really what matters. And you can test this in that way. Has
every single, let's suppose there are 1,900 shareholders. Supposing instead of buying 18% from 2 shareholders, I don't think you suggest that if they'd bought small shareholdings all round accumulating 18%, they could be said to have acquired control from a previous controller.
For there would be one major different factual assumption in what you said, is that the prior block would still be there.
Right.
The prior block would still be there. What they do by acquiring PAD and Anglo is not simply acquiring, but also taking. It's the same block of shares. And about this titanic struggle to get control, which did happen in 2006 because the current board didn't play ball. What has happened between 2007 and 2017? Exactly what happened for all these years before with the prior management, which is that the small shareholders went back in their dens, nobody's worried anymore, and people like Mr. Galea and Mr. Mayer are busy doing what people like Mr. Galea and Mr. Mayer do, which is control the company, in the same way as these 3 companies were controlling before because they had appointed the board.
What are you doing?
Well, I'm afraid, may I use the usual advocate's excuse of saying I was interrupted a fair bit. If I were to be given a little bit of leeway, I could wrap up in, shall I say, 10 minutes?
10 minutes.
But we could do that at 2 if you'd rather.
Well,
it would give me time to go through my notes and pare them down.
Take it off your reply.
Sure, no, that is entirely acceptable.